Any mention?
My lord, I beg to mention item 11, my lord. I am praying for 2 weeks' time, my lord.
Who is on the other side? Who is on the other side? Yes.
No objection, Lordship.
Yeah, for the state respondent.
My lord.
No objection.
No objection.
At the request of the state respondent. At the request of Mr. R. Gurun Lordnik GA, referring for the state respondents. This is matter after 2 weeks. Yes.
Deeply.
My lord, I beg to mention two items, my lord, 21 and 24, my lord. 21 is 21 connects to those POXO matters, my lord, out of love affairs. So this matter is in the division bench, my lord. That's coming out on 4th of February, my lord. The reference case, my lord. So my lord may kindly adjourn this matter. 21.
Shall adjourn it for how long?
My lord, now 2 weeks or 2 weeks first, my lord.
But then if you say that it is dependent upon the outcome of the...
Yes, my lord.
Anyway,
So
let it be.
then we'll make a mention after 2 weeks, my lord.
21 just said the request of the petitioner, this is matter after 3 weeks.
3 weeks, my lord.
Deeply.
And 24, my lord, senior counsel is there, my lord. I've just taken consent. We need to file one petitions or small applications, my lord, which will be doing it. So, my lord, this may come up after a week.
This petition is about what? Mr.
My lord, this is a quashing of the FIR, my lord.
What petition is required to be filed?
And because we were saying that because similar allegations was already filed earlier also based on the inquiry report, my lord, and that case has been already been charge sheeted. Yes.
That will be a matter of merit. When it is matter is hard, you can raise it.
Yeah, my lord, I have yes, that issue that I have brought before my lord, and my lord directed me to file a small affidavit to that effect, my lord. So I'm just taking 2 days.
Any order passed?
There is an order passed, my lord. So a week's time, my lord.
Maybe let it be 2 weeks time, your lord.
This is also the same order for the 2 weeks.
Obliged, my lord.
Obliged, your lord.
Please, your lordship, I beg to make a mention for item number 17. Lordship, I pray for adjournment for 3 weeks time, your lordship. Obliged, your lordship.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 18.
Yes.
I pray with 2 weeks time, Lordship.
You are mentioning on behalf of the petitioner.
Petitioner, yes, Lordship. I have no objection, Your Lordship.
Same. Yes.
Obliged.
Please, Your Lordship, I beg to make a mention of item number 12. Lordship, I'm seeking some accommodation on this matter. My senior counsel is having some personal difficulties.
I'm appearing on behalf of the respondents, Your Lordship.
That is, you were supposed to take some instruction.
I was supposed to get some records. Your
Have you
Lordship.
received your...
I have not yet received also, Your Lordship. I'm still awaiting.
Then we'll adjourn it at the...
Yes, Your Lordship.
At the
2
request of the
weeks.
petitioner. Yes, as the request made on behalf of the petitioner and not objected to by the learned senior counsel appearing for the respondents. List is matter after 2 weeks. Yes.
Obliged, Your Lordship.
Lordship, similar prayer for item number 14. Item number 14.
14.
Lordship.
Yes.
Lordship, Lordship, in this case, they are supposed to get instruction, Lordship, under EPFO provision 7I, the matter is appealable.
Alternative remedy. Availability of alternative remedy.
Yes, Lordship. So they are supposed to get instruction, but it's long pending, Lordship. We need to also look, because since 2017 it is pending, we have to give report for what purpose it is pending,
Not
Lordship.
2007, it's 2020 matter.
Sorry, Lordship, 2020. We need to give report also, Lordship, for
You
what.
take instruction also, you see, you are supposed to take instruction. Why you have not taken it? If there is an alternative remedy, then definitely there is no use of person. Moreover, there is a direction, recent direction by the Apex Court, not to entertain a matter where they are, until unless there is something seriously wrong. Yes. How long you want it?
Lordship, 2 weeks.
Lordship, this may be the last chance because we also need to give report, Lordship. We are
Use this,
also.
madam, giving last chance. We have seen giving last chance, although nothing happens. So either we dismiss or we go ahead with these things.
Lordship.
Yes, yes, order after 2 weeks. Yes. At the request of the petition. Yes.
Lordship, similar pay of item number 16.
Who is appearing for the respondent here? MECL? State is a party here. State is a party here, Mr. Guru.
State is a party. I'm sorry.
Nobody is there for the MECL. We'll inform them.
Yes.
Yes, this also, right same or same request. After 2 weeks.
Lordship. Lordship, similar pay of item number 15.
Item 15 here for the respondent.
Your Lordship.
Item 15, Mr. Hajarika, you are there?
Yes, my lord.
You are appearing for?
For state respondent.
Who is for the petitioner then?
Petitioner is Mr. Ayub Khan.
Then? Have you informed him? No.
No.
Then? What is to?
Will inform.
It just says requested by so and so. But I counsel let me further list this matter after 2 weeks.
Highly obliged.
Yes.
Your Lordship, I beg to mention item number 13. Kindly
Yes.
let this matter come after 2 weeks.
Why? Why?
We're still doing some research on it.
What research? This is a 2019 matter. It's a service matter, isn't it?
Yes, Your Lordship.
Appearing for the state.
Yes, Your Lordship.
This petitioner is still in service.
No, Your Lordship.
You do not know.
No.
Is there any purpose keeping this matter pending?
We're still doing some research, Your Lordship.
If you are not in service?
Lordship, this matter has been heard also.
Yes, it was heard and subsequently it was transferred back to some other court and then it has come back again. So it has to be reheard again because the court doesn't remember everything. But then I think this is pending for quite some time. It was heard at.
Yes, Your Lordship.
So what is to be done? No objection to the prayer.
No objection, Your Lordship.
You are also appearing for the
Respondent number 5.
school managing committee.
Yes, Your Lordship.
As requested by the learned counsel for the petitioners. And not object to by the learned counsel appearing to the respondents. List this matter for 2 weeks. Yes.
Obliged, Your Lordship.
Wait, please, Lordship. Lordship, I beg to mention item 20, Lordship. Lordship, this matter is pending before division bench, Lordship. Similar matter.
This is a POXO.
This is a POXO matter, Lordship. This matter can be taken out.
Yes. Yes, Mr. Abram.
Yes,
Come on, 2 weeks. 3 weeks. At the request made on behalf of the petitioner, this is matter 3 weeks. Yes.
Also, similar prayer for item number 5, Lordship. 5 to 9, they are connected matters. These matters, Lordship, it's pending before division bench or before the Supreme Court, Lordship.
Item number 5 to 9.
I'm appearing only for item number 5, Lordship. For the petitioner in item number 5.
Who are for the other petition, other parties?
Lordship, this item 5, 6, 7A, Your Lordship, are linked to item 1 and item 4, Your Lordship.
So these are item 4.
Item 5, 6, 7A.
So let this item 1 be called and then
Lordship,
we
yes.
Yes. Yes.
Daily cause list, item number 1.
Ahmed, this is Your Lordship.
Yes.
Lordship, in fact, this matter is hearing pending before the Honorable Supreme Court and judgment has been reserved, Your Lordship.
So just the same order will pass.
Lordship,
so it will come up after 4 weeks or when shall
It will come after 4 weeks, Your Lordship.
And then if this, say supposing the decision of the Supreme Court will cover, then that
Yes,
is-
Your Lordship.
that will.
Lordship, I am item 1, 567A.
Okay, we'll just say that is pending before the apex court. That is what.
Lordship, yes.
The same order will suffice in all the matters.
Only, Your Lordship, liberty may be granted, Your Lordship. As and when the matter is.
That is always remains, you see.
Lordship, then.
That liberty, you see, that is always there. To file a mention, you do not need a liberty.
Obliged.
Yes. This what's the same thing? Last order. Learned, just say it. Learned counsel appealing for the parties submit that the connected matter pending before the apex court is yet to be disposed of. Then say in view of the submission, release this matter after 6 weeks.
Lordship.
After 6
Obliged,
weeks.
Your Lordship.
6 weeks.
6 weeks we will do, Your Lordship.
After 6 weeks to avoid the outcome of the matter pending before the apex court.
Obliged,
Yes.
Your Lordship.
Item number 2.
Yes, Mr. Suna, what is this?
Yes, my lord, this is a case where the petitioner before your lordship has sought
This has come from the other bench.
It has been recused by his lordship, Mr.
Why? Why?
On the ground that there's an anonymous letter. In fact, my lord, has on two or three questions, my lord, in the coordinate one has already taken up the matter, and even the interim order has been passed in our favors. And subsequently, on 12th, when the matter was laid out, the courts expressed its opinion of recusing him.
Okay, it's all right. It's all right. This is anticipated bail application.
Yes.
Yes.
So, my lord, before I would.
Interim order is there with you. Whether the
Till such date only.
case diary was called for. Case diary was called for or not?
Yes.
It was.
No, my lord, before I would come to the application, what I would like to, if my lord permit me, on that day we have been shown that letter, it has been written, so I would like to make my submission on that point as to who has written that letter, that such kind of letter, which we are taken by surprise.
Where is that letter? What is that letter? Addressed to whom?
Addressed to the judge himself. It was there in the report.
No, but then what do we have to do with the letter?
What
bearing it will have here?
No, my lords, in my humble and respectful submission, it is a letter which disturbed the admission of justice by the court. Otherwise, indirectly it amount to intimating the court not to take up the matter. My lord, we have the letter because on that day we cannot. Let us see what
This is addressed to other judges' thing. We cannot open it. This is by name. It has come by name. What bearing you have to do with it? You argue your case. Forget about the letter part. Maybe because of this letter, the court has recused, isn't it?
No, my apprehension, my
now
lord.
case diary is ready with you.
It was not called.
It was not called. So we'll have to call the case diary before. You are having interim.
No, till 11, my lord.
What is the order?
Order 28th October.
So if it is 28, 10.
28, 10, my lord.
No, it is not a limited thing. You have interim prayer. Interim. Have you seen the check the order?
Yes.
Yes.
Till then.
No. What is the use of seeing it? Yes, it doesn't seem, Mr. Suna, that there is any time-bound order.
Yes, my lord.
Have you seen the order? No. So nothing. So you are on interim bail.
My lord.
So you can call for the CD and go for.
Then my lord.
Yes.
My lord, I am the complainant in this case,
yes.
My lord. So through my through the White Court order dated 28 only, I have been allowed to file my intervention application. So I filed my intervention application, Lordship.
Intervention in a bail application.
Bail application.
Why state is there, isn't it?
Lordship, here.
Is there any provision of law?
Lordship, here what happened, Lordship, the petitioner has misleaded the court, Lordship.
Forget
He-
about that. See, the prosecution is there, they will take care of that because they have registered a case. So we'll go to that. But then you show us, if you say that you have filed an application for intervening, just show us the law. We do not know. Where is the provision?
Lordship, according to BNSS section 335.
Kindly enlighten the court. We do not know.
330.
But my lord, in her application, my friend did not quote any provision of law.
Doesn't matter. That doesn't matter. If law is there, it is not
Yes.
required to be quoted. So let us see
338 BNSS.
This chapter concerns with regard to general provision as to inquiries and trials. Yes. Yes.
338.
The appearance by public prosecutors.
Yes,
Yes.
Lordship, according to this section, also I can file an application. Lordship.
Where is that? Please read out the relevant
The
part.
public prosecutor or assistant public prosecutor in charge of a case may appear and plead without any written authority before any court in which the case is under inquiry, trial, or appeal.
Yes.
If in such case any private person instructs his advocate to prosecute any person in court, the public prosecutor or the assistant public prosecutor charge of the case shall conduct the prosecution, and the advocate so instructed shall act therein under the direction of the public prosecutor or the assistant public prosecutor, and may, with the permission of the court, submit written arguments and after the evidence is closed in the case.
But then, does it apply at this stage?
Lordship, there is a reason also, Lordship, why I have filed this.
We are more on law. We are more on law. You see, like you just show us law that at this stage you have. This speaks about trial. When a person is prosecuted,
Lordship.
then here the prosecution, the question of prosecution, there is no charge sheet against you, isn't it?
No, there is no charge.
No. So there is where is the question of prosecution? Now it's an investigation. Now what right you have at this stage?
Lordship.
This provision was there in the earlier thing also, CRPC also, isn't it?
The CRPC section 301 was there, Lordship.
Yes.
Lordship, the only reason I have because the
You have filed a petition.
I have already filed.
Have you filed an objection to that?
I have not.
Do you intend to file?
I intend to file. If my lord.
If you intend to file, you intend. Otherwise, we do not know. See, like, but then if there is nothing to allow you, then why should we allow?
Lordship, there is Lordship of ground because the petitioner has misleaded the court.
We can understand. See, that happens at this stage. It is very likely that parties may listen. But then the thing is that where do you have the right to intervene at this stage? You show us the law, then we will allow you.
Lordship, though this provision 338 of BNSS is there, Lordship, but it is, yes, it is under when the case is under trial, Lordship. Not but being a complainant, Lordship, the problem is that if the here the tricky matter is, Lordship, here the
See, madam, whatever the case is, that you do not have to seek, you do not have to right to seek this detention. Whether detention is needed or not, that is for the prosecution. You are not the investigating authority.
no, Lordship,
Now,
just I am
kindly just remember one thing. The detention during the bail period has nothing to do with penalty. You are not penalizing him. So, detention during bail period is only for the purpose of facilitating investigation. What hand you have in the investigation? You may have a good case so far as the fact is concerned. You may say that the petitioner is lying. Let the prosecution reply. You have no right. Whether a person is needed for investigation or not, you do not have any say.
Lordship, I am not stressing on whether he is needed for whether he is, because that part prosecuted my learned senior who is there, he will highlight, Lordship. The only part I have been aggrieved by the petitioner is that he is misleading the court. In para 7 of the petition,
We are concerned. Right now we are concerned with an application which speaks about detention. So we will not go into all those other aspects. It doesn't matter. We will not record any finding on merit at this stage. Even if you say that they are lying, we are not. This court cannot record any finding of merits at this stage. So you should not be worried about that. It will not have any effect so far as merit of your case is concerned, or your accusation is concerned.
Lordship, in the misleading in the way, Lordship, what happened, Lordship, there is already an anticipatory bail the accused person has already obtained previous, for which I am affected, Lordship, because the anticipatory which he has already obtained in previous cases, there are 4 FIRs against the same accused person. And Lordship, in one case he has already obtained anticipatory bail. Subsequently, he is getting anticipatory bail in this case. He is mixing up all the cases together, and I am a victim of his manipulation in one of the case, Lordship.
That is why. That is why you filed a complaint.
And Lordship, Lordship, the problem is that, Lordship, in my case, he has already after getting this anticipatory bail in previous case, he has already threatened me, Lordship. He has already said he has already legal notice and threatened me, Lordship.
Legal notice is not a threat.
No, Lordship, in the legal notice he has threatened me, Lordship.
No, legal notice he can threat about only the part which law allows.
Yes, Lordship, but
illegal threat. Okay, you reply to it.
Lordship, we have.
Has he said that he will kill you in that legal notice and all, or something like that? He will cause you physical harm, or he will kidnap you, he will abduct you, something like that. What's that kind of threat? What is the threat in thing? See, madam, you know it very well. It is not that you are not a seasoned lawyer. What is that? Okay, we will not passing any order right now in your application. You show us law. If you show us law, otherwise. See, because so far as this court understands, at the stage of investigation, you have no role to play except furnishing your information to the investigating authority. That is what you do not have. So far as the right of a person is concerned, detention, the during investigation stage, you have nothing to say. Nothing. No role to play. You show us that you have a role to play, we will allow your application.
Lordship, may I point out one more thing, Lordship? Lordship, while signing the application, Lordship, when he signed the petition along with the affidavit, the accused person was not present even in Shillong.
Let the prosecution stand these things. You are here to see. This is not helping you, madam. You are trying to divert it. You just reply to the query of the court. You show us that you have a right, we will allow. Where is the application? What is the application of your application? What is the number? Has it been numbered?
This case number 115.
You have not filed a show cause. This case number 115. See, madam, until unless you can show anything, we will reject this application.
Lordship, under provision 338 only, Lordship, the provision is only in CRPC 338. Lordship, that provision is there. But we have filed this application.
That comes with the latest is prosecution. What is the question of prosecution?
We have sought the permission of the court before filing this.
That is all right. That is all right. You see, nobody can stop you from filing an application. Now, whether it will be allowed or not allowed, that is what is to be decided, isn't it? Now, if you want it to be allowed, then give us some law. We are not saying that you are prevented from filing it. Maybe rightly, wrongly, you have filed it. You prepare yourself, come on the next day, we will just see.
Lordship, by the time my senior might have any submission, Lordship, I don't know.
Yes, anything you want to say at this stage?
So at this stage, no, it's between
You
them.
will be producing case diary.
In the meantime, let them file a show cause, and at least once he files a show cause on a petition.
That is all right. I don't think you are coming here. You
No, I don't know.
There is in between them.
No.
And you can produce the case diary, or shall we call for the case diary after this petition is dismissed?
After this petition.
So you will file in.
Not required, my lord. It's not a point law. If so, subject to my
Execution
friend
of-
can
execution of
satisfy.
law, isn't it?
Yes. So my friend can satisfy my
So,
lord.
madam, do you intend to take some more time in this thing, or shall we? You want us to pass some order here, now, right now, in your application? Yes. Hard learner council. This is miskis number 115. Appearing to the parties. Stop. Paragraph by this application. The petitioner has prayed for allowing him to intervene in the bail application, in the anticipated bail application filed by the respondent number 2. Stop. The learned counsel for the. But this will be for the applicant. Do not write petitioner. Yes. Learned counsel for the applicant submits that the applicant is a complainant, basing on which Anapada PS case number 25/7/2024 was registered against the respondent number 2, and the respondent number 2 no, you do not say. Beforehand, you give a full stop. You just say. The learned counsel submits that the respondent number 2 has preferred that the anticipatory bail application number 18 of 2014 by making some untrue and false statement in order to mislead the court. In order to obtain anticipatory bail by misleading the stop. It is a submission of the learned counsel that his participation in the hearing of the anticipatory bail application filed with the respondent number 2. Do not say his participation, her participation. It should be is necessary for the purpose of placing the true fact of the case before this court. and prays that the application seeking intervention in the matter may be allowed. Stop paragraph. Mr. Suna. Mr. Khan, you have any submission to make here? No submission.
It's between them, Your Lordship. At this stage, I don't think so. Because had he
You
filed
don't have- you're neither
because
for
yeah,
or against.
absolutely, absolutely, Lordship. Had he filed a show cause, maybe then I would have some material. But he didn't file a show cause. So I
No,
don't know.
otherwise you do not want intend to say anything.
At this stage, no.
It's all right. Okay, Mr.
Lordship, just one small submission may be recorded, Lordship, that in their the petition which they have filed, Lordship, they have signed the affidavit without being present in Shillong. Lordship, they have filed the affidavit when they were not present in Shillong.
See, madam, let this issue be raised by them. You are not a party. See, until you are allowed to intervene, we will not record anything what you say with regard to anticipatory application. First, you have to establish your right. That you have a right. If that is the thing, let the state take that. This application has to be authenticated. You see, there has to be authentication, isn't it? It has to be signed in before the oath commissioner. So this will go on oath commissioner, how the oath commissioner has signed it. Who is the oath commissioner here?
It's notary who has signed.
So notary who has signed. So notary public will be have to, if that be the thing. So we will be entering the different arena.
Exactly. Yes.
What is the last name? It's a learned counsel. They're paying for the. Before that, you just say Mr. K. Khan, learned additional IG has submitted that he has no submission to make in this application. Stop. Next paragraph, we just say Mr. H.M. Suna, learned counsel appearing for the result number 2 files. Result number 2 submits that there is no provision in law which allows a complainant to intervene at this stage, and the application for intervention has been filed without citing any provision of law. He submits that since there is no law which allows a complainant to intervene at this stage, for the purpose of raising an objection against his application of grant of anticipatory bail, the present application cannot be entertained and is liable to be rejected. Stop. Paragraph. Upon consideration of the submissions made by the rival parties and on consideration of the averments and materials before this court, it is found that the petitioner has not been able to place before this court any provision of law which allows the applicant to intervene when an application seeking grant of intervene in an application seeking grant of anticipatory bail. Stop. Though during the course of hearing, the learned counsel for the applicant has drawn the attention of this court to section 338 of C certificate 38 BNSS 2023. C 38 within bracket subclause 2 you just give. To buttress her submission. Come on. The said provision is it does not seem to apply at this stage. Stop. The law, the provisions contemplated in 338 supposed to allows and private person to engage an advocate of his choice to assist the public prosecutor or assistant public prosecutor at the stage of trial of a case. And may submit written argument after evidence in the seat. Case is closed. Stop. A perusal of the proposed provision does not show that the complainant in a criminal case has any right to intervene and oppose the anticipatory bail application filed by the accused in the case. Hence, the present application is not supported by any provision of law. Stop. Paragraph. In view of the whatever, in view of the discussions made over, this application is devoid of merit and is rejected. Stop. Yeah. And the main case, you write in the anticipatory bail application, heard learned counsel for the parties. Let the how many respondents are there? There's only state is a respondent in the anticipatory bail application.
Yes, sir.
Yes. In this anticipatory bail application number 18, huh?
My lord.
Heard learned counsel for the parties. Call for the case diary. Stop. The yes, when you will produce the case diary?
At least 10 days also. 10 days. 10 days.
10 days.
10 days.
So we'll have it after 2 weeks.
2 weeks.
As prayed for by learned AG, appearing for the state. Release this matter after 2 weeks for production of case diary and the hearing and hearing of this application. Yes.
Similar order may be passed in a subsequent.
There's another application. How many accused are there?
2 accused are there. The AB number 18 and 18.
There also there is an application for intervention.
Same, my lord.
Same order.
Same order.
Same order, only the name of parties and case number required to be
So
changed.
this is item.
This is item 2.
This is item 2 and this is item 3. The same order. There also you will file an intervention application. Okay.
Only name of party required to be changed.
Name of party will be
case
different.
number.
Name of party will be different.
Yes.
Just check it and out. This rest will be seen. Yes.
Much black now.
Hearing item number 19.
Yes, what
May
happened?
it please your lordship? Your lordship, we have filed an application for a plea of juvenility, my lord.
Yes.
And this honorable court was pleased to remand back this matter to the trial court, white dated 12 August 2024 for the plea of juvenility, my lord.
Yes.
Then the inquiry had occurred in the trial court, my lord. Then, my lord, the inquiry had already completed and the report has been filed before this honorable court.
Yes.
And my lord,
Report is in your favor or not?
the report is not in my favor.
What? That's not in your favor.
Yes, my lord. But my lord, my humble submission is that, my lord, as per the previous order, my
So
lord,
your plea of juvenility is rejected.
in the trial court, yes.
That is what?
Yes, my lord. It's rejected in the
Yes.
trial court, my lord. But with that, respect to that submission, my lord, I would humbly submit that this honorable court may kindly grant me another 1 week time, my lord, to advance my arguments on the miscase
Yes,
number.
definitely. Why not? This is a new.
Yes, 56
prepare
of.
yourself because you can. She can again challenge that this thing that.
Lordship, yes, that is the remedy is there to challenge, but not here. Lordship, I will not.
You're not open up now.
I'm
Until
not
unless
going
without
to
saying
open
others.
up the Lordship. Only Lordship, may kindly directed the registry to furnish us a copy, Lordship.
Whether that is this report is there with us.
Yes, my lord. The learned trial court has remanded back the entire
If
files.
the report is available in the, then it may be given to the state, Your Lordship.
Case record has come. Just is it there?
Let me assist Your Lordship.
That is the order, sir.
What was your age? What is according to you at the time of incident?
At the time of incident, my lord, I was a juvenile because the date of
As per you, what was your age?
because I have a birth certificate and my date of birth was 07/04/1999. So at that point of time, at the time of incident, my lord, I was below 18 years of age.
Lordship, that is the report on top.
May it please your lordship?
Yes.
We have filed our objection, lordship.
Your lordship, we need 2 weeks of time. Kindly allow us.
This is a petition praying for what?
For under 482, lordship.
Quashing.
Lordship.
Seeking quashing
Lordship.
of a criminal proceeding.
My lord.
Not on the basis of compromise.
No, lordship.
Yes. MS NG Shilla, learner senior GA, paying for the state respondents submits that an objection in this matter has already been filed. MS P. Yadav.
Yes, your lordship.
P. Yadav, learned counsel appearing for the petitioner, acknowledges receipt of a copy of the objection and prays for grant of some time to allow the petitioner time to enable the petitioner to go through this. Stop in view of the hour. In view of the prayer made. In view of the prayer made. Come on, list this matter after
2 weeks, lordship.
2 weeks.
Yes, your lordship.
Much obliged, lordship.
Highly obliged, your lordship.
Item number 23.
Lordship, I'm praying for some accommodation in this matter, your lordship.
Yes. This is for hearing, otherwise it's for fixed for hearing.
Lordship, in the last occasion, we've already given a submission, your lordship. Now it's for the respondent to give the submission, your lordship.
What case is this?
Item number 23, your lordship.
What is this about? What submission you have given?
We are challenging the order dated 5/6 of 2024, your lordship.
Was it hard, Mr. Abraham?
Your lordship, in this case, R. Gurung is leading this case, and he was very much inside the courtroom, but he has to leave for some urgent personal difficulty. So, if this matter may be taken up by next Monday.
That is okay. Was it hard?
So I have no idea because I was just instructed by my colleagues that he has to leave.
Okay. This is a murder case, isn't it?
Yes, your lordship.
They are seeking quashing. Is it?
Yes, your lordship. It's a partner matter, your lordship.
Yes. Partner, of course, when the partner matter comes up like this, after a gap of such a long time, then the court forgets, you see, nothing remains. Then you have to again refresh. Anyway, since you are praying for this thing, is it a partner matter? Have you passed an order? Partner, keeping it partner.
Order dated 6/11/2024, your lordship.
Yes, but then it has not been kept partner. It is only thing. It says that order has been heard at some length. Yes. MS. Are you there in this thing? You are advocate on record here in this matter.
Lordship, I'm appearing on behalf of A.R. Pasa, your lordship.
So you have to say that. Give her name. Take her name. Learned counsel appearing on behalf of Mr. A.R. Pasa. Learned counsel for the petitioner. Praise for adjournment of the matter by 2 weeks. Mr. Abraham, learned counsel appear for the state respondent. Learned GA appearing for the state respondents. Has no objection. Prayer alert. List after 2 weeks. Yes, sir. Yes. No other matter.